Peace and blessings, and don't you dare go testing. It's the Gizar, the always the get Flizzar, the Wizard, decking the boy Izar, the Tizar, destined to get the lenses, clearing up all the lenses. One path is the way that I'm taking, getting closer to God, the tight situation. We're back with another video, another reading for you good folks. The name of this one is titled The Exemption by Moses G. Washington. It was revised 10/19/2004. And the disclaimer reads, the material in this essay is for educational purposes only, and not to be construed as legal advice about what you should or should not do. The information herein is to assist you in performing your own due diligence before implementing any strategy. Formal notice is hereby given that you have 10 days after reviewing any material on this website to notify Truth Sets Us Free in writing of any word, phrase, reference, or statement which is inaccurate, incorrect, misleading, or not in full compliance with state and federal law, and to give TSUF 30 days to correct and cure any alleged potential flaws. Truth Sets Us Free intent is to be in strict compliance with the law. In this essay, we will examine the evidence that the government owes each American a huge debt, and that this debt can be used as an alternative to using Federal Reserve notes to discharge our debts. In order to best understand the material in this essay, you should have already read the articles on U.S. bankruptcy, Federal Reserve, and Meet Your Straw Man. Throughout this document, we will be quoting various sources. The quotes will be shown in blue ink and a sans serif font. The regular text of this essay and comments in the midst of quoted text will be shown in black ink and a serif font. I will also occasionally underline certain texts to draw your attention to key phrases. Constitutional money. We will begin our study of this subject with a review of what the Constitution has to say about money. Congress shall have the power to coin money, regulate the value thereof, and of foreign coin. Article 1, Section 8, Clause 5. No state shall make anything but gold and silver coin a tender in payment of debts. Article 1, Section 10, Clause 1. From these quotes, we can conclude that the people have delegated power to Congress to coin money and set its value. The states also formed an agreement agreeing that only gold and silver coins will be valid payments of debts. This concept of paying a debt will be very important to our discussion. So let's see how pay is defined. Pay, to discharge a debt by tender of payment due, to deliver to a creditor the value of a debt, either in money or in goods, for his acceptance. Black's Law Dictionary, 5th edition. While the above definition uses the word discharge, we do not believe that pay and discharge carry the same meaning. You will notice that pay carries with it the concept of deliver to the creditor the value of a debt, either in money or in goods. This means that pay includes the concept of exchange. Exchange, to barter, to swap, to part with, give, transfer, for an equivalent. Black's Law Dictionary, 5th edition. So the idea of an exchange is one in which two parties transfer items one to the other for life value. We conclude from this definition that an exchange pays a debt in full. Both parties receive something of equal value. Now let's take a look. Now let's look at the definition for discharge. Discharge, to release, liberate, annul, unburden, disencumber, dismiss, to extinguish an obligation. Black's Law Dictionary, 5th edition. It is clear from this definition that discharge is very different from pay. It is evident that there is no exchange of value occurring when a debt is discharged. The system that was set when our republic was founded allowed people to pay their debts. Gold and silver, both are substances that have been recognized to have intrinsic value for thousands of years. If someone wanted to buy a cow and a price of $20 was agreed to between the buyer and the seller, an exchange takes place between the parties when the buyer exchanges the $20 piece of gold for the cow. Our concept of money has changed from the founding of our country from being gold and silver coins to paper money, not backed by gold, fiat money. These concepts begin to change after the Civil War. Legal tender cases. During the Civil War, the United States government issued greenbacks, which was money backed by nothing, fiat money. This was a significant change from the systems that was established in the Constitution. These greenbacks were very similar to our current Federal Reserve notes. There were a number of legal cases that ruled on the constitutionality of the greenback currency. In each of the initial cases, the courts ruled that the greenbacks were unconstitutional. But the Knox versus Lee case reversed the prior decisions of the Supreme Court. This case decided that the government could issue legal tender that is not backed by gold and silver, thus paving the way of the Federal Reserve Bank in 1913 and the confiscation of the gold in 1933. The following excerpts are taken from the case. In order to understand this decision, it is important to realize that the Supreme Court was acting as a court of equity, which operates under different rules than a common law court. The presumption in the court of equity is that the government is sovereign, owning everything, and that the defendant and the plaintiff are U.S. citizens. As citizens, they are both viewed as debtors to the sovereign government. The court that covers action between two debtors in the U.S. is an admiralty court, which operates under equity rules. Given this presumption, it is perfectly valid for the court to make decisions regarding who owes who what debt. The court is acting like a parent who resolves disputes between two children over who has the right to a toy that both children want. The court believes it is right and fitting for them to tell the parties what the sovereign government wants done with the assets that they, the plaintiff and defendant, are using. The argument presented by the Attorney General Ackerman reflects this attitude of sovereignty resting with the government. Ackerman suggests why the national government should be able to issue paper currency that is not backed by gold. Congress, to exercise the power conferred by the Constitution, then the means which it selects are constitutional, whatever may be the opinion of the court of its practical wisdom, because the decision, whether practically conducive to the end proposed, is a political and administrative question, and not a judicial one. If the government needed gold and it was in the possession of A, it could take it from him, as they could take his personal service against his will, or could batter down his house if it stood in the way of military operations. Much of what is done that seems to violate the Constitution is done under the law of necessity, which derives its authority from military or martial law. This case was after the Civil War had concluded, but the Attorney General is arguing as if the war was still being fought. If A had said, I owe this gold to B and I'm on my way to pay him my debt, the officer of the government could accompany him to his creditor, and when the payment was made, seize it from him. What difference does it make whether it was the form in which it was done, or whether it was taken from A and there was furnished him certifies that the money belonged to B and intended for him was taken by the government, which would be responsible to B for its payment. Attorney General Ackerman, Knox versus Lee. Ackerman is suggesting that since the government has the right to take the gold, it doesn't matter if they take it from person A, the debtor, or if they take it from person B, the creditor. Ackerman's presumption is that the government has the right to the gold. If the government has the right to the gold, then they can just give A a piece of paper, a certificate, or legal tender that A can give to B. Ackerman suggests there is no difference. If the government took the gold and other substance-based money, then the government will be responsible for all debts because they took the substance-based money out of circulation. The government is given a certificate in its place. Since the government removed the ability of the people to pay, the government is responsible for the debt. If the government took the gold out of circulation, it will be responsible for all debts because the government is the only one with the ability to pay. No one else has anything of substance with which to pay. We have heard it said that he who had the gold makes the rules, but it can also be said that he who has the gold pays. The following excerpt from the Knox versus Lee case shows how the composition of the court was changed in order to get the desired ruling. A majority of the court, 5-4, in the opinion which has just been read, reverses the judgment rendered by the former majority of 5-3 in pursuance of an opinion formed after repeated arguments, excessive terms, and careful consideration, and declares the legal tender clause to be constitutional. That is to say that an act of Congress making promises to pay dollars, legal tender as coin dollars in payment of pre-existing debts, is a means appropriate and plainly adapted to the exercise of powers expressly granted by the Constitution and not prohibited itself by the Constitution, but consistent with its letter and spirit. And this reversal, unprecedented in the history of the court, has been produced by no change in the opinions of those who concurred in the former judgment. One closed an honorable judicial career by resignation after the case had been decided, after the opinion had been read and agreed to in conference, and after the day when it would have been delivered in court, had not the delivery been postponed for a week to give time for the preparation of the dissenting opinion. The court was then full, but the vacancy caused by the resignation of Mr. Justice Greer having been subsequently filled and an additional justice having been appointed under the act, increasing the number of judges to 9, which took effect on the first Monday of December 1869. The then majority found themselves in the minority of the court as now constituted upon the question. The Chief Justice Chase dissenting, legal tender cases, Knox versus Lee, 79 U.S. 287 319 in 1870. But it has been claimed to be a proper regulation of commerce for Congress to provide a uniform national currency, and that these legal tender notes were, in effect, a mortgage on the whole property of the nation. This is very similar to what was said during testimony on the emergency banking legislation passed on March 9th, 1933. See the quote below. And therefore, the best secured and most uniform currency the nation could have. Although in truth, the security for this or any national debt is exactly the extent to which the people will consent to contribute through taxation to its payment. Knox versus Lee. The case from 1870. The Knox versus Lee case set the stage for what happened in 1913. Federal Reserve Act was passed. See the Federal Reserve article. And in 1933, when the country was taken off the gold standard. Events of 1933. You may recall from the United States bankruptcy article that shortly after Franklin Delano Roosevelt was inaugurated, he called a special session of Congress. He asked Congress to pass emergency banking legislation. On March 9, 1933, Congress passed an emergency measure that FDR requested, declaring a banking holiday. The fundamental nature of the banking system was changed in this legislation. As a result of the legislation, all banks had to become members of the Federal Reserve System. This act further made the Federal Reserve note the only paper currency valid in the U.S. The Federal Reserve notes were no longer going to be backed by gold, but only by the credit of the people and their property. A quote from the congressional record that occurred during the debate on the bill demonstrates this fact. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Congressional record, March 9th, 1933, emphasis added. The language sounds very familiar, what was said in Knox versus Lee case shown above. The next major change that occurred was an executive order issued on April 5th, 1933. This order required all individuals, partnerships, associations, and corporations to determine their goal in the essay. Meet your strawman. We have already seen that partnerships, associations, and corporations are legal fictions created by the civil government. However, the term individual and person are used in the order. What do these terms mean? Individual. As a noun, this term denotes a single person as distinguished from a group or class, and also very commonly a private or natural person as distinguished from a partnership, corporation, or association. But it is said that this restrictive significance is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. See also person, Black's Law Dictionary, 5th edition. Person in general usage, a human being, in other words, natural person, though by status, term may include a firm, labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. Black's Law Dictionary, 5th edition. Natural person, any human being who as such is a legal entity and distinguished from an artificial person like a corporation, which derives its status as a legal entity from being so recognized by law. And that's from Raven Law Dictionary. Natural persons of the body politic owe an allegiance to the state. That's the case Pembina versus Penn, 1888. Human, number 1, belong to man or mankind. 3, profane, not sacred or divine. American Dictionary of the English Language, from 1928. Human being, see monster. Law Dictionary with pronunciations by James Ballantyne, a 1948 edition. Monster, a human being by birth, in some part resembling a lower animal. Dictionary with pronunciations by James Ballantyne. Our conclusion is that person and individual are terms referring to legal fictions or straw man. Both of these words are also said to be natural persons, and as such are members of the body politic owing allegiance to the state. These entities are created in and exist in the civil society that we call the public. As such, they are subject to the rules established by their creators, the civil government. Men, on the other hand, are outside of the public. You might think of the public as if it were a box that contains only legal fictions, and men live outside this box. Since the executive order applies to individuals and persons by necessity, it did not apply to men. Below is the complete text of the executive order with some embedded comments. Executive Order of April 5th, 1933. Under Executive Order of the President, issued April 5th, 1933, all persons. The order applies to persons, which did not include men. So when men turned in their gold, they did so voluntarily. Are required to deliver on or before May 1st, 1933, all gold coin, gold bullion, and gold certificates now owned by them to a Federal Reserve Bank, branch, or agency, or to any member bank of the Federal Reserve System. Executive Order forbidding the hoarding of gold coin, gold bullion, and gold certificates. By virtue of the authority vested in me by Section 5B of the Act of October 6, 1917, as amended by Section 2 of the Act of March 9, 1933, entitled An Act to Provide Relief in the Existing Emergency in Banking and for Other Purposes, the state of emergency due to the law of necessity was used as an excuse for issuing the order, in which a mandatory act Congress declared that a serious emergency exists. I, Franklin Delano Roosevelt, President of the United States of America, do declare that said national, the use of the word national seems to signify the civil government acting as sovereign while under the original intent of the Constitution. The people were viewed as sovereign and the source of all authority. Emergency still continues to exist. Pursuant to said section, do hereby prohibit the hoarding of gold coin, gold bullion, and gold certificates within the continental United States by individuals, partnerships, associations, and corporations. The order only applies to these entities, but men were excluded from the order, and hereby prescribe the following regulations for carrying out the purposes of this order. Section 1. For the purpose of this regulation, the term hoarding means the withdrawal and withholding of gold coin, gold bullion, and gold certificates from the recognized and customary channels of trade. The term person means any individual, partnership, association, or corporation. Again, the order applies only to artificial entities and not to men. Section 2. All persons are hereby required to deliver on or before May 1st, 1933 to a Federal Reserve branch, to a Federal Reserve Bank or branch or agency thereof, or to any member bank of the Federal Reserve System, all gold coins, gold bullion, or gold certificates now owned by them or coming into their ownership on or before April 23rd, 1933, except the following. A. Such amount of gold as may be required or legitimate and customary use in industry, professions, or art within a reasonable time, excluding gold prior to refining, and stocks of gold in reasonable amounts for the usual true requirements of owners mining and refining such gold. B. Gold coins and gold certificates in an amount not exceeding in the aggregate $100 belonging to any one person, and gold coin having a recognized special value to collectors or rare and unusual coins. C. Gold coin and bullion earmarked or held in trust for a recognized foreign government. Men are foreign to the government. They are outside the box or outside the public, or foreign central bank or the Bank for International Settlements. D. Gold coin and bullion licensed for other proper transactions not involving hoarding, including gold coin and bullion imported for re-export or held pending action on application for export license. Section 3. Until otherwise ordered by any other person becoming the owner of any gold coin, gold bullion, or gold certificates after April 23rd, 1933, shall within these 3 days after receipt thereof deliver the same in the manner prescribed in Section 2, unless such gold coin, gold bullion, or gold certificates are held by any of the purposes specified in paragraphs A, B, or C of Section 2, or unless such gold coin or gold bullion is held for purposes specified in paragraph D of Section 2, and the person holding it is, with respect to such gold coin or bullion, a licensee or applicant for license pending action thereon. Section 4. Upon receipt of gold coin, gold bullion, or gold certificates delivered to it in accordance with Section 2 or 3, the Federal Reserve Bank or member bank will pay therefore an equivalent amount of any form of coin or currency coined or issued under the laws of the United States. The value of the gold have been arbitrarily held to a fixed value by the federal government. It was not permitted to float in value as it is today. If someone turned in $10,000 worth of gold, the bank was given an equivalent amount of currency. On the surface, it would appear that value, $10,000 in gold, was given for value, $10,000 in currency. However, the gold had real intrinsic value, while the currency was worthless paper. This was not an exchange, but rather a transfer of the gold from men to the government. Section 5. Member banks shall deliver all gold coin, gold bullion, and gold certificates owned or received by them, other than as exempted under the provisions of Section 2, to the Federal Reserve banks of their respective district and receive credit or payment thereof. This indicates that the Federal Reserve banks are holding the credits for the gold. Section 6. The Secretary of the Treasury, out of the sum made available to the President by Section 301 of the Act of March 9, 1933, in all proper cases, paid the reasonable cost of transportation of gold coin, gold bullion, or gold certificates delivered to a member bank or Federal Reserve Bank in accordance with Section 2, 3, or 5 hereof, including the cost of insurance, protection, and such other incidental costs as may be necessary upon production of satisfactory evidence of such costs. Voucher forms for this purpose may be procured from Federal Reserve banks. Section 7. In cases where the delivery of gold coin, gold bullion, or gold certificates by the owners thereof within a time set for the above will involve extraordinary hardship or difficulty, the Secretary of the Treasury may, in his discretion, extend the time within which such delivery must be made. Applications for such extensions must be made in writing, under oath, addressed to the Secretary of the Treasury, and filed with the Federal Reserve Bank. Each application must state the date to which the extension is desired, the amount and location of the gold coin, gold bullion, and gold certificates in respect of which such application is made, and the facts showing extension to be necessary to avoid extraordinary hardship or difficulty. Section 8. The Secretary of the Treasury is hereby authorized and empowered to issue such further regulations as he may deem necessary to carry out the purpose of this order and to issue licenses thereunder through such offices or agencies as he may designate, including licenses permitting the Federal Reserve banks and member banks of the Federal Reserve System in order for an equivalent amount of other coin, currency, or credit to deliver, earmark, or hold in trust. This is a vitally important concept. The federal government set up a trust where the Secretary of the Treasury is acting as the trustee. The people voluntarily transfer their gold to the government. The gold and perhaps what's other things are the assets of the trust. The people would also be the beneficiaries of this trust. Gold coin and bullion to or for persons showing his need for the same for any of the purposes specified in paragraphs A, C, and D of Section 2 of these regulations. Section 9. Whoever willfully violates any provision of this executive order or of these regulations or of any rule, regulation, or license issued thereunder may be fined not more than $10,000, or if a natural person may be imprisoned for not more than 10 years or both, and any officer, director, or agency of any corporation who knowingly participates in any such violation may be punished by a like fine, imprisoned, or both. This order and these regulations may be modified or revoked at any time. Franklin D. Roosevelt, the White House, April 5th, 1933. Further information, consult your bank. Gold certificates may be identified by the words gold certificate appearing thereon. The serial number and the Treasury seal on the face of a gold certificate are printed in yellow. Be careful not to confuse gold certificates with other issues which are redeemable in gold or which are not gold certificates. Federal Reserve notes and United States notes are redeemable in gold but are not gold certificates and are not required to be surrendered. Special attention is directed to the exceptions allowed under Section 2 of the Executive Order. Criminal penalties for violations of Executive Order. Our conclusion after analyzing the order is that men voluntarily gave up their gold, a substance with intrinsic value, for worthless paper. The gold was held in trust for the people by the government. The Secretary of the Treasury acts as the trustee of this trust. The people, and by extension their children and heirs, are the beneficiaries of this trust. This means we have a beneficial interest in the assets of the trust. We will see later that other assets were also given to the government. The next major step was making it illegal to require gold as a valid form of payment for debts. This was done by House Joint Resolution 192. Below is a complete text of House Joint Resolution 192. Joint resolution to suspend the gold standard and abrogate the gold clause. June 5th, 1933. House Joint Resolution 192, 73rd Congress, first session. Joint resolution to assure uniform value to the coins and currencies of the United States. Whereas the holding of or dealing in gold affects the public interest and then forth subject to the proper regulation and restriction, and whereas the existing emergency, again, an emergency was used as an excuse for the action, has disclosed the provisions of obligations which purports to give the obligee a right to require payment in gold or any particular kind of coin or currency of the United States or in an amount in money of the United States measured thereby, obstruct the power of the Congress to regulate the value of the money of the United States, and are inconsistent with the declared policy, Congress is setting a public policy which is defined as principles and standards regarded by the legislature or by the courts as being of fundamental concern to the state and the whole society. Black's Law Dictionary, 7th edition. Of the Congress to maintain at all times the equal power of every dollar coined or issued by the United States in the markets and in the payments of debts. Now, therefore, be it resolved by the Senate and House of Representatives of the United States of America and Congress assembled that A, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payments in gold or a particular kind of coin or currency. Currency will include all of M1, M2, and M3 money as defined by the Federal Reserve, or in an amount in money of the United States measured thereby is declared to be against public policy, and no such provision shall be contained in or made with respect to any obligation hereafter incurred. This clause makes it contrary to public policy for any creditor to require payment in any particular form. This means that no creditor can ask for payment by check, cash, or cashier's check. It also means that they are not permitted to dishonor a valid form of payment. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged. You can no longer pay off a debt. You can only discharge a debt. Upon payment, dollar for dollar in any coin or currency, which at the time of payment is legal tender for public and private debts. Any valid form of legal tender must be accepted to discharge a debt. The debt must be discharged dollar for dollar, which means that we can discharge the exact amount shown on a charging instrument, bill, or invoice. Any such provision contained in any law authorizing obligations to be issued by or under authority of the United States is hereby repealed, but the repeal of any such provision shall not invalidate any other provision or authority contained in such law. B. As used in this resolution, the term obligation means any obligation, including every obligation of and to the United States except in currency, payable in money of the United States, and the term coin or currency means coin or currency of the United States, including. The term including means that what follows is a partial list, and it implies that other things may also belong in the list. The term includes, on the other hand, is a limiting term that indicates only the specific items listed may be included. Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. Section 2, the last sentence of paragraph 1 of subsection B of section 42 of the Act, entitled An Act to Relieve the Existing National Economic Emergency by Increasing Agricultural Purchasing Power to Raise Revenue for Extraordinary Expenses Incurred by Reason of Such Emergency, to provide emergency relief with respect to agricultural indebtedness, to provide for the orderly liquidation of joint stock land banks, and of other purposes. Approved May 12, 1933, is amended to read as follows. All coins and currencies of the United States, including, due to the use of the word including, other things may also be valid currency. Federal Reserve notes and circulating notes of the Federal Reserve banks and national banking associations, heretofore or hereafter coined or issued, shall be legal tender. Just because other forms of payment are not listed does not exclude them from being valid forms of legal tender. You will notice that checks and credit cards are accepted, but these instruments are not listed. For all debts, public and private, public charges, taxes, duties, and dues, except that gold coins, when below the standard weight and limit of tolerance provided by law for the single piece, shall be legal tender, only at valuation in proportion to their actual weight. Approved June 5th, 1933, 4:40 p.m., 31 U.S.C.A. 462, 463, House Joint Resolution 192, 73rd Congress, Session 1, Chapter 48, June 5th, 1933, Public Law Number 10. One sample court case that ruled on the legality of House Joint Resolution 192 was Guaranteed Trust Company of New York versus Henwood, 307 U.S. 247, 1939. This case held that House Joint Resolution was lawful. Some interesting excerpts are included below. Analysis of the terms of the resolution discloses. First, the Congress declared certain types of contractual provisions against public policy in terms so broad as to include then existing contracts as well as those thereafter to be made In addition, future use of such prescribed provisions was expressly prohibited, whether actually contained in an obligation payable in money of the United States or separately made with respect thereto. This prescription embraced every provision purported to give an obligee a right to require payment in 1, gold, 2, a particular kind of coin or currency of the United States, or 3, in an amount of United States money measured by gold or a particular kind of United States coin or currency. Congress, apparently to obviate any possible misunderstanding as to the breadth of its objective, ended with studied precision a catch-all second sentence, sweeping in every obligation existing or future payable in the money of the United States, irrespective of whether or not any such provision is contained therein or made with respect thereto. The obligations hit at by Congress were those payable in money of the United States. All such obligations were declared dischargeable upon payment, dollar for dollar, in any coin or currency of the United States, which at the time of payment is legal tender for public and private debts. That which the joint resolution made dischargeable was the debt, the monetary obligation to pay. Congress sought to outlaw all contractual provisions which require debtors who have bound themselves to pay United States dollars to pay a greater number of dollars than promised. The resolution intended that debtors under obligation to pay dollars should not have their debts tied to any fixed value of particular money, but that the entire obligation should be measured by and tied to the actual number of dollars promised, dollar for dollar. The enacting part of the resolution prescribes every provision which purports to give the obligee a right to require payment in gold or particular kind of coin or currency or an amount in money of the United States measured thereby, and declares every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any coin or currency which at the time of payment is legal tender. Obligation, it states, means an obligation payable in money of the United States. Thus, the resolution proclaims that it is aimed at gold clauses and declares, if language is to be taken in its plain and most obvious sense, the provisions requirement payment requiring payment in gold dollars or measured by gold are illegal, and that every promise or obligation payable in money of the United States shall be discharged dollar for dollar in legal tender currency. As a result of House Joint Resolution 192, the people can no longer pay their debts. They have nothing of value to give in exchange for the goods and services they need. According to House Joint Resolution 192, we can only discharge our debts. This was a huge change in our society, but very few people realized what had occurred. The following diagram shows what happened when House Joint Resolution was passed. You will notice that some entities are inside a box. These are what we are calling the public. Men contributed their gold and other assets and became beneficiaries of a public trust, but persons are considered impostors. So knowing one's status when attempting to access the benefits of the trust is vital. Everything inside the box either serves as a fiduciary or a manager of the trust. The Secretary of the Treasury also serves as the trustee and the receiver of the U.S. bankruptcy. The person in this box position is the only individual who can see both inside the box, the public, and outside the box, into the private. So the exemption looks something like this. Created with the United States Congress and House Joint Resolution 192, June 5, 1933. The man, which has substance and is the creditor, acting as principals and creditors. No possession of gold because they took the gold out of circulation. In possession of silver, earth, houses, cars, and businesses, which they also took possession of. They take possession of when you register these particular things with the state. Now they become basically owned by the government. The state owns it. So the fiduciaries would be the Federal Reserve banks. They took the gold, right? Fiduciaries, they also, when you register your car, and you got the county recorders and the deeds of trust with the loan applications, recording applications, they give you a certified copy, title insurance application policies, so there's county recorders, corporation commission, city, state, business license application, public schools enrollment. This is people applying for services from government. You got the Department of Treasury. John Snow was the treasurer at the time. Trust Management Team, Internal Revenue Service, Department of Justice, Federal and State Courts, Securities and Exchange Commission, Department of Economic Security, Department of the Interior, Department of Commerce, Secret Service, etc. Imposters, persons. He who has the gold pays the bills or provides an exemption. Title to property. And we're going to stop right here and come back at a later date and read the next 7 pages to this particular item titled The Exemption. So right now we're up to page 12. When we come back at a later time, and I'll give you the rest of this document titled The Exemption by Moses G. Washington. What you got to understand here, people, is this is basically explaining the situation that the people was in as creditors of the United States bankruptcy. The United States is bankrupt. It's a bankrupt entity. When you get a chance, you can look up. Let me see what it is. And we can look it up right now, too. As a matter of fact, we will do that. I believe it's 28 United States Code. Let's do that right now, actually. Let's do it. 28 United States Code. Subsection 3002, 15A, which we have right here. And this is definitions from Cornell University. So it's 28 United States Code, subsection 3002, definitions. So we're looking for number 15A. And the United States means a federal corporation. The United States is a corporation, which means it's a business. The United States is a corporation. It's a business. It's not necessarily what you think it is. And then we can also see the United States is in debt. And that will be under, I believe it's 27 CFR 7211. See the meaning of the terms. And we go here. Actually, no, that's commercial crimes. All right, the United States is a debt. It's actually it's in the Uniform Commercial Code. Let's get that up here real quick. The Uniform Commercial Code. I know where it's at. I know exactly where it is. You should see 9307H. Let's get that up here. United States. All right, so location of a debtor. And this is from Uniform Commercial Code 9307. And we go down to the letter H. And here you can see the location of the United States. The United States is located in the District of Columbia. Now, what are we looking at here, people? Location of debtor. The United States is a bankrupt entity, and the people are the creditors. Yeah, we're going to get back to our exemption. We'll get back to the exemption at a later point in time. Thank you, people, for listening. Peace and blessings.